Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. On 31/7/2023, 2 days back, Honorable Supreme Court of India, two judges bench, Justice S. Ravindra Bhatt and Arvind Kumar, in the case of Muhammad Asfaq, A-S-F-A-K, Muhammad Asfaq Alam versus State of Jharkhand and another, in criminal appeal number 2207 by 2023, dated 31/7/2023, held that Arnesh Kumar guidelines, they have to be followed in letter and spirit, and the states, the high courts and the DGPs, once again they have to send instructions to their junior courts and also the subordinate police officer to follow the Arnesh Kumar versus State of Bihar 2014 guidelines in letter and spirit. So prior to Arnesh Kumar guidelines, situation was like this. If any woman is subjected to cruelty, if any woman is subjected, married woman is subjected to dowry harassment, then such case was created as a case of 498 of the Indian Penal Code. Of course, since it is non-bailable, even though the punishment is 3 years, the police authorities, they used to arrest the accused persons. Maybe husband, okay, no problem. But maybe the relatives or sisters of the husband who are far away residing elsewhere, who do not have any connection with the case, and they have to languish in jail for days together. When such was the condition, during the year 2014, this Arnesh Kumar versus State of Bihar and others came into force, and Honorable Supreme Court of India gave directions in this guidelines in this case, particularly whenever you hear the case of Arnesh Kumar, no mechanical arrest in 498 case. That's the crux of the case. No mechanical arrest. Because nowadays, no doubt, we feel sympathy with the women who were harassed, with the women who were shown cruelty by the husband or his relatives. But nowadays, those cases are less, and the revenge part by the woman and false cases are becoming more. This is the ground reality. Then, in such a case, no doubt, there may be a case against the husband, there may be a case against the mother-in-law. Luckily, the woman, they don't report any allegations or harassment by father-in-law. Because normally he will not be available in the house, he will be going to the fields and other things, he is not much bothered. And in such a case, so they have to languish in jails. Therefore, Arnesh Kumar guidelines, they clearly stated that no mechanical arrest. If arrest is necessary, you can give him 41-year notice. What is the purpose of arrest? Arrest is to see that he attend the court on the dates of adjournment without fail. So therefore, if you are satisfied, if the police officer is satisfied by giving a notice him under 41 years CRPC, and if he is satisfied that those fellows will come to the court, then they have a point of arrest. Then, but there are certain cases, definitely, where the police officer is of impression that harassment will still continue. Threatening of the wife may be there. In such a case, definitely he can arrest the accused. In such a case, he has to give the reasons for the arrest. And when arrest is made, the grounds of arrest should be informed to the magistrate within 1 week or so. So very strict guidelines are given in the Arnesh Kumar case. They have to be followed in letter and spirit, because the decision came into year 2014 and now we are almost 9 years have completed. People, they have got a tendency to forget the same. Now coming to the facts of this particular case, Afsaq Alam and his wife. The marriage took place on 5/11/2020. Right? Okay. It went on for some time. Well, later differences cropped up between the couple, and the woman filed a case of 498A, 506, 323 is also there, 323, 504 and 506 of the IPC, together with the Dowry Prohibition Act, other things, so many sections, normally they will club them. So, when the FIR was registered, normally the husband, he will go to the court. So, since 498A is unavailable, and of course, he knows that the police are hunting for him, the allegations are very serious. So, he has approached the local district court, PDJ court, for anticipatory bail under section 438 crpc. But the bail was rejected, that there is a lot of investigation to be done, and it is a very nascent stage to give bail. So, agreed by the order of the district court, he went in appeal to the High Court. Of course, High Court has given some protection to him till the investigation is completed. He may not be arrested. Right? The progress is the investigation has been completed and charge sheet has been filed. At the time, once again, he approached the High Court, but the High Court did not give him any relief, and without granting bail, they said go and surrender before the police. Aggrieved by this, he came to the Supreme Court. Supreme Court clearly said that when the charge sheet is filed, no doubt the High Court has given protection of not to arrest till the investigation is completed. The investigation is completed, so he has to be given the bail. Instead of that, once again, the High Court asked him to go and surrender before the police and then apply for the regular bail. This is not correct. If you follow the Arnesh Kumar guidelines, so this is a case of 498A. When the case is of 498A, maybe 324, maybe the 324 is altered voluntarily causing simple hurt. 506 is the 504, and this is nothing but criminal intimidation. They are very simple sections. Major section is 498A. When it is itself is punishable for 3 years or less, then where is the point of anticipatory bail? So, what is the case? So, Lalit Kumar, all these cases they have discussed, but anyway, they are not important for us. So, therefore, ultimately, Supreme Court said, please remember, the orders of the High Court asking him to surrender on 18/1/2023 and get regular bail, it is not correct. Because arrest, it is a restriction to the personal liberty under Article 20 of the Constitution of India. Court is there to protect the same. Jail or bail, normally bail. So, once again, Arnesh Kumar case came into surface, and all of you, please read the Arnesh Kumar judgment and guidelines. Definitely, you will be having better knowledge, particularly on 498A or cruelty or harassment cases against women. Thank you.